Gentlemen, thank you for being here. I need to ask about the rule change from April 14th, which shortens the length of days on union certification, but it also allows access to personal information of the workers. My question is, what processes or regulations have been put into place to help protect workers who don't want their personal information, their email, their cell phone numbers, their home addresses, their shift times shared with any outside organization? Has there been a process or regulation put in place to protect those workers who don't want that information shared?
Well, thank you, Senator Lankford, for giving me an opportunity to address that question. It should be known that the Supreme Court has set forth, and this is 50 years worth of law, that has required employers to supply the names and addresses of employees in the bargaining unit to the union that has filed the petition in advance of the election. That is supported by the Supreme Court. What this does is take into consideration modern technology where email addresses are common modes of communication, and those and cell phone numbers were available to the employer.
So is there any regulations intact that when that information is shared, email, shift times, cell phone numbers, from any entity that gets that outside, what they do with that information, how it's distributed, how it's collected, how it's managed, the security of that information? I mean, it's pretty private information.
I understand that it's very private information. This information is being supplied to a party to an election process. That's the party that is entitled to it under these rules.
Correct, but what do they do with it? What limitations do they have with that information? Is there any regulations on them what they do with that information?
If they abuse the use of those regulations, that information, unfair labor practice charges can be filed against them. Objections to elections can result.
Could they sell that information? Could they distribute it to another union outside of their community? Could they distribute it to other like-minded individuals or outside groups?
There has not been any documented cases where I have seen.
Is there a limitation on that, on sharing their personal information with another group?
The limitation that we have placed on them is that the abuse of that information would be a basis for unfair labor practices or objection.
I'm not talking about the abuse of the information. I'm talking about sharing that information. They've now collected private information of individuals. I don't want to believe this because I have other questions on it, but if the local job training program came and said, we want the shift times and the private information because we want to do vocational training for people here, they couldn't get that information. If the local fire department walked in and said, we want all this information, they couldn't get that. If the FBI walked in and said they want that information, they would have to get a subpoena to get that information. But this information is shared, and I can't seem to find a regulation that then restricts how that group that gets it then manages that information. That's the question I want to ask.
The rule specifically deals with that information being used solely for the purposes of the election.
Well, I'd be interested to know that regulation, how that's managed, because that is a potential that's sitting out there for individuals' private information, for individuals that don't want to share that information. I do have some very serious concerns on the shift in the franchise rule as well. Because of the way the definition is sitting out there, Mr. Griffin. In your brief, you made the statement that your concern was it inhibits meaningful collective bargaining, and I believe the term was direct, indirect, or potential control over workers. The potential control over workers has a tremendous broad definition that this particular board may have an understanding of, but 10 years from now, 15 years from now, what does the potential control over workers and how far does this go to broaden this definition? We have hundreds of thousands, literally, of franchises around the country, and I have a couple issues here. One is, has there been any study of what happens with a significant change in our economy, with a significant change in the franchise rule? Has there been any evaluation of the economic impact of that? And I'm interested in this comment about the workforce has changed significantly in the past several decades, and so we need to return to a rule that we set aside 30 years ago. Because there's been so much progress and change, we now need to do something we used to do a long time ago. Those two don't seem to jive to me.
Well, thank you very much. Senator, for asking on this and the follow-up. A couple of points. The first is, it has always been the case, regardless of whether it is the current standard or the prior standard, that the board looks at a number of factors in making this determination, and in each instance, it's a very fact-bound determination. What we are suggesting is a return to a standard, and incidentally, the EEOC filed a brief arguing that this standard also be adopted because it is the standard that is applied in EEOC cases currently. And so the EEOC made the point that the board law and essentially all labor enforcement law ought to operate on the same joint employer standard. But that what we'd be arguing for is, in conjunction with the EEOC, is looking at additional factors, and that, again, on a fact-bound, individualized basis, if there was sufficient demonstration that the putative joint employer had sufficient involvement, including examining indirect involvement, examining potential involvement, that meaningful collective bargaining could not take place without them present at the table, then they should be held to be a joint employer. And it's always going to be a fact-by-fact determination.
So, and my time is up, but there has not been an economic study on the impact of this.
Well, there were briefs filed on both sides of this in the Browning-Ferris case. There were a number of briefs filed that said the joint employer standard ain't broke, don't fix it. And then there were a number of briefs urging a change. And many of those briefs cited economic studies and other information. The board itself did not conduct a separate economic study, and is, in fact, statutorily prohibited from doing so.
We'll have time for another round if you have time, Mr. Shelby.
Thank you.
Thank you, Mr. Chairman. I want to come back again to the franchise issue. The concern is there's so many hundreds of thousands of businesses around the country that are franchises that know the rules right now. The concern is, you're talking about saying that so much has changed in the business world over the last 30 years that we need to return to a rule that we had 30 years ago to catch up with what has happened in the last 30 years. Changes significantly the rules of the game. And in a time when we have increasing complexity in federal regulations and local and state regulations, many small businesses need additional help just trying to keep up with the rules. They're not trying to break the rules, they're trying to keep up with the rapidly changing pace of the rules. So my question is, when the issue is direct, indirect, or potential control of an employee, how that gets defined in a way when they're dealing with just basic quality standards and verification of standards, which a franchisor would want to do. They want to make sure that the franchises that are out there are maintaining quality standards, but it suddenly creates this varied rule of where is control, where is not control, what's indirect control, what is potential control of an employee when they may be just giving counsel on a very complicated set of labor laws.
Thank you, Senator, because this is an ongoing dialogue, obviously.
And is very, very important to us, especially in our economy.
And it is very important, and it's important that we're clear about it. And the first thing, just to emphasize, is that under the old standard, the standard that we're talking, the traditional standard that we're asking a return to, there are these cases where if the franchisor is just seeking to maintain the quality of the brand or product, the uniformity of the brand or product, they're not a joint employer, and we've specifically said we're not seeking to overturn those cases. That's number one. Number two, in each of these cases, the small business is the franchisee. And in each of these cases, if there's a merit determination made, there's no question that the franchisee has committed an unfair, if it's adjudicated, the facts are demonstrated, the franchisee is the one who has committed the unfair labor practice. The issue here is with respect to the large business, the franchisor, and whether or not they are jointly responsible in any way, shape, or form. So in terms of the small business either is on the hook if it's a merit determination or they aren't if there's no merit. And as I indicated before, the vast majority of cases, 60% of these cases are dismissed. So with respect to the franchisor, There is no open case currently in the United States where we're seeking to hold a franchisor liable under the new standard. In each instance where we're seeking to hold a franchisor liable, at this point, it's under the current standard. We are arguing...
Right, you're asking for the old standard.
For the old standard,
right.
And we're arguing for it because, in our view, there are instances where the franchisor goes beyond seeking to protect the brand or product, goes beyond the indirect impact on employment that comes in that situation, and has a more immediate impact on employment or a bigger impact on employment. And under those circumstances, if particular facts are present, we think that the franchisor should be a joint employer. Now, we also think that there are circumstances, and this recent advice memo in nutritionality is a classic example, where the franchisor does not have sufficient involvement and therefore should not be held responsible.
The issue is you're opening up this opportunity for a lot of litigation here. Every time a franchisor engages with a franchisee, and any of that back and forth conversation that's common, especially with someone that's new, that's starting a business, the first time franchise owner, that they're trying to get a business started, they're asking for lots of advice, and suddenly the larger company has to back up and say, I can't give you counsel, I can't engage at that level because suddenly that's going to connect all of us. When in the past that was common to try to help someone get off the ground. You want training, you want equipping, you want people to be able to move in and start small businesses. My concern is this creates this artificial wall that actually diminishes the quality of our businesses, diminishes the incentive to start new franchises, and puts this fear into franchisors that I can't really engage with the quality oversight and verification that I used to do.
Well, Senator, as I indicated, if the nature of the engagement has to do with maintaining the quality of the brand or product or the uniformity of the brand or product, there are cases on that, and we have explicitly said, and I repeat, that we are not seeking to overturn those cases.
I understand that, but when the redefinition changes to direct, indirect, or potential control, there's a lot of interaction between these companies, and you know that full well. And the words potential control can mean a lot of things, and that does create just the fear of this wall that I'm concerned will diminish the quality of our companies across the entire country and will discourage people from buying into franchises, or will set the standard so high that franchisors will not release out authority to people that would like to start a first-time business, but it's only going to be people that already have established businesses, and it's tougher to get in the market. Now, again, I know this is hypothetical, but you're wading into territory that has serious long-term implications for our economy and for a lot of people that want to start small businesses. And I would tell you to tread carefully, and I'm aware you're trying to get the courts to engage in this rather than the board to actually have to make this rule, and I get that. But I'm telling you, when this comes around, this is going to have long-term impacts, and I would encourage us to go more careful and with more comment than what we're doing. I've got to yield back. Mr. Chairman, thank you.